Traditional etiquette suggests the ring should cost about 2 months of the giver's salary, so a broken engagement or a divorce can leave both parties wondering who legally owns an expensive symbol of commitment. Understanding the legal rules about engagement rings in Illinois helps answer that emotional question. Under Illinois law, an engagement ring is considered a conditional gift. This means that when one person proposes and says, "Will you marry me?" while offering a ring, the gift is conditioned on the couple going through with the marriage. If the couple never marries, either party may go to court seeking replevin, which is a lawsuit to repossess property that is being wrongfully held. Illinois law defines replevin as a remedy when goods or personal property have been wrongfully taken or detained. When someone files a replevin action for an engagement ring, the court asks which person's act ended the engagement. It does not consider why the relationship ended or who might have been at fault. The person who breaks off the engagement loses the ring. If the ring giver calls off the wedding, the ring stays with the person who received it, and if the person who accepted the ring ends the engagement, the ring must be returned. If the person in possession of the ring has already sold it, the replevin action is no longer appropriate. The wronged party must instead allege conversion, which occurs when someone's property is taken without authorization. In that situation, Illinois law allows the aggrieved party to recover the market value of the ring at the time and place it was sold, plus legal interest. Jewelers frequently provide documentation showing the value of a ring, so proving damages is usually straightforward. WHO gets the engagement ring if the parties never married? When the engagement ends before marriage, the ring is a conditional gift. Illinois cases such as Vann versus Vehrs and Harris versus Davis confirm that a gift given in contemplation of marriage is conditioned on the subsequent marriage of the parties. Because the marriage never took place, the court focuses on which party acted to end the engagement. A replevin lawsuit allows the party who did not end the engagement to recover the ring. There is no legal analysis about why the relationship ended. If the ring giver breaks the promise, the receiver keeps the ring, and if the recipient ends the engagement, they must return the ring. When the ring has been sold, the remedy shifts to conversion, and the seller must compensate the other party for the ring's market value. WHO gets the engagement ring if the parties did marry? Once a marriage occurs, the condition tied to the gift is fulfilled. A divorce court will not use replevin because the ring is no longer a conditional gift. Instead, the court classifies the ring as either marital or non-marital property. Under the Illinois Marriage and Dissolution of Marriage Act, property acquired by gift or before the marriage is considered non-marital. Since an engagement ring is both a gift and property obtained before the wedding, it is typically awarded to the spouse who received it. The law presumes that property acquired before the marriage is a gift to the individual spouse, and that presumption can only be rebutted with clear and convincing evidence. Therefore, in most cases, the spouse who wore the ring keeps it after the divorce. WHO gets the wedding bands in an Illinois divorce? Wedding bands are usually of lesser value than engagement rings, and there is no Illinois case law that explicitly decides who owns them after a divorce. These bands are purchased with non-marital money and exchanged as a symbol of the marriage. Because each band is given to the marriage rather than to an individual, some courts might view wedding bands as marital property. In marriage dissolution cases, a gift to the marriage is treated as marital property, which means the bands may be divided in the overall distribution of assets. However, most couples see little practical value in keeping the other person's wedding band, so disputes over them are rare. Even though engagement rings and wedding bands can be significant financially and emotionally, they are often minor assets compared with issues like parenting time, child support, maintenance, and the division of marital property. A lawyer can help determine whether a ring is marital or non-marital property and guide you through a divorce or a broken engagement. If you have questions about a family law matter, speak with an attorney who understands Illinois gift and replevin laws. At the law offices of Russell D. Knight, Our Chicago family law firm can answer your questions and help you focus on the more substantial aspects of your case. To discuss your situation, contact our law firm at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, or call 773-334-6311 to speak with an attorney.